Yeah, Mouton.
That's right.
And Mr. Burbank, will your client waive the formal reading of the indictments in each of the cases?
Sure will, Your Honor.
Before we go forward, I'm also going to take judicial notice in all of the court's files on Ms. Mouton. Ms. Mouton was examined for competency to stand trial by Dr. Capon. I received that report dated July 21st of 2026. The finding after that examination was that Ms. Mouton was competent to stand trial. Is there any other evidence with regard to competency?
No, Your Honor, I've received the report. I would say for the record that through my representation of Ms. Mouton, she has answered all my questions. She understands the proceedings. So I feel confident to move on with this plea agreement.
Thank you. Anything else from the state?
From the state.
Then based on that information from Mr. Burbank, as well as the report, I am going to find that Ms. Mouton is currently competent to stand trial. We going on count
We can go and count.
one only, at least in the first one,
And all of them.
all of them. Okay. Get that pulled
There
up.
are 2 second degrees and 1 state jail.
Okay. Ms. Mouton, in cause number 25, DCCR 0907, the state has elected to proceed on count 1 only. It alleges that you committed the second-degree felony offense of assault on a peace officer, and that was from May 2nd of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
Sorry, I've got to get it pulled up the right way in each of the cases to make those notations. Now, in cause number 25, DCCR 1466, the state has also elected to proceed on count 1 only. It alleges again that you committed the second-degree felony offense of assault on a peace officer from August 17th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you did what they charged you with?
Yes, ma'am.
And then finally, in cause number 25, DCCR 1467, you're charged with the state jail felony offense of possession of a controlled substance from August 17th of 2024. And how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they've charged you with?
Yes, ma'am.
In all 3 of these cases, I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Burbank?
Yes, ma'am.
Do you fully understand it?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1 in each case.
No objection, states 1 in each case, Your Honor.
It's admitted in each case. All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily. Again, make that finding that you're mentally competent and you understand the nature and the consequences of your pleas. And cause number 25, DCCR 0907, find sufficient evidence to find you guilty and at this time finds you guilty of the second-degree felony offense of assault on a peace officer. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 25-1466, also finds sufficient evidence to find you guilty, and at this time finds you guilty of assault on a peace officer. Sentence you in accordance with that agreement to a term of 5 years in the institutional division of the Texas Department of Corrections. You'll also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then finally, in 25-1467, finds sufficient evidence to find you guilty, and at this time finds you guilty of possession of a controlled substance, a state jail felony. Sentence you in accordance with your agreement to a term of 20 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These 3 cases will run concurrently, which means together at the same time. I'm also going to sign dismissals as part of this agreement, and cause numbers 25 DCCR 1468 and 26 DCCR 0120. I've handed you the trial court certifications in each of your cases that shows that these were agreements and I did follow them, so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Burbank. All right, good luck to you, ma'am. Thank you.
I be excused, Judge.
Yes, sir. Thank you, Mr. Burbank. Are you Jalen Hendricks?
Good morning as well.
And this is cause numbers 23 DCCR 2323. In that case, Mr. Hendricks is on probation for evading arrest or detention with the use of a vehicle. A first amended motion to revoke probation has been filed in that case. And then we also have 25 DCCR 0574. Mr. Hendricks is also on probation in that case for evading arrest or detention with the use of a vehicle. And there is a first amended motion to revoke community supervision in that case as well. Mr. Rojas has filed motions asking that bonds are set in both of those cases. And Mr. Rojas, do you intend to call your client?
I do, Your Honor.
Mr. Hendricks, the best you can, raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You may proceed. Go ahead.
You're Jalen Hendricks, right?
Yes, sir.
Jalen, where were you born?
Jefferson County.
Have you lived in Jefferson County your whole life?
Moved around from group home to group home.
When was that? Is that because you were in CPS care?
Yes, sir.
Have you ever lived outside of Jefferson County?
Yes, sir.
Okay, where was that at?
Houston, Dallas, Power, Texas. I came back to Beaumont at 17.
Speak up, please.
Houston, Tyler, Texas, Dallas. Then I came back to Beaumont at 17.
Thank you.
And all those other places that you lived, that was because you were moved around through CPS care, is that right?
Yes, sir.
Your only family is here locally in Jefferson County, is that right?
Yes, sir.
And that's your grandmother?
Yes, sir.
You don't have any other family, do you?
No, sir.
I think you told me you have a fiance though?
Yes, sir.
Okay, what is her name?
Jasmine Briscoe.
Chadlin Briscoe. Do you own any property that you could sell? A house, a car, land, a boat, trailer, anything like that?
No, sir.
Okay. Do you have a bank account?
Joint bank account.
A joint bank account with who?
My grandma.
Okay, and do you know how much money, about how much money is in that bank account?
1,000.
About $1,000. And do you put money in that account? Does your grandmother put money in the account?
You both do.
You both do. And where did you get your money from that goes into that account?
Social Security.
And is your grandmother working right now?
No, sir.
Okay, where does she get her money from?
Social Security.
So, you're asking the judge to set a bond this morning. How long have you been in jail right now?
Since August 5th.
And you're on probation for 2 felonies. And before you got placed on probation, you were sitting that time out in jail, weren't you? You were waiting in jail to get probation?
Yes, sir.
Um, and so is it due to the fact that you think you may have $1,000 in the bank? And how much do you get a month for your social security?
About $200.
$1,200?
Mhm.
Okay. Is it realistically, how much money do you think you and your grandmother and your fiance could come up with in order to make a bond?
Just 2 or 3.
Two or three, what,
Uh,
about $2,000 or $3,000? Okay. Um, and so are you asking the court to set your bond somewhere in the neighborhood of $20,000?
if she allows me,
Okay. Now, do you have the $2,000 or $3,000 with you right, or do you guys have that right now, or do you have to wait a little bit more time to come up to save that money?
I have to save a little bit.
Okay, so even if she were to set the bond at $20,000, you wouldn't be able to get out today, but hopefully in maybe a few weeks, your grandmas would be able to have that money.
Yes, sir.
Pass witness.
No questions.
All right, thank you. Any other witnesses?
No, yeah.
Mr. Smith, what is the state's position?
Judge. He's not entitled to a bond because these are both straight probations. These were not my cases. These were Mr. Coleman's that transferred to me after he left the court. Spoke with his probation officer and she is here if you have questions for her, Judge, but it seems like he does report regularly and I think he tries to pay fees as he can, but everything else he just doesn't. He got kicked out of immoral recognition therapy twice.
What's the status of the new assault? And we're talking about this,
I think it's filed, they're just carrying along with this case.
I mean, he's talking about this female, like they're together, but there's a
I'm
bond
sure there's gonna be a
condition that he
bond
have
condition.
no condition, that no contact with her, because that's an allegation in this motion.
If does Ms. Briscoe, does she live with your grandmother or does she have her own house?
She got her own house.
Okay, now you understand that if you were to be released on bond, that one of the conditions, probably in this case, but for sure in the misdemeanor case would be that you don't have any contact.
That's fine.
And you're telling the judge you want to stay away from her?
Yes, sir.
Can you double check? Let me hold this for a second, what the status of that is down the hall, so have a better idea. Just have a seat over there for a second, or wherever the bailiff wants you. I'm gonna recall your cases in just a minute.
Yes, ma'am.
Thanks. All right, we're back on with Jalen Hendricks, and what did you find out about that? I'm sorry.
The case is pending. It's in Judge Wood's court and his next setting is a jail docket in there September 24th.
All right, so any other evidence or argument with regard to setting bonds in these cases?
No, Judge, just to point out that I think these are his only felonies that he's ever had. He's got limited misdemeanor history, but I think these are his only felonies. So,
Mr. Smith, anything else?
No, Judge.
So, Mr. Hendricks, the problem I have is, well, a couple things, but first of all, it looks like you were placed on probation December of 2025 for 2 evading arrest. So you had one from back in 23, while you're on bond, you get another one and you get this opportunity at probation. And then we've got a new offense and we've got the fact that you just cannot seem to follow through with at least this MRT class and some other things on your probations.
I guess a couple other things, Judge. Probation brought to my attention the fact that the address they have for him is actually the apartment where the victim does live. So he was living with her at the time. There's also an emergency magistrate protective order that's good for at least 90 days. It prevents him from moving around her for 90 days on top of the bond conditions that you have set. So he did it, I believe, say that he was living with his grandmother, that he was living with her until he went to jail. Living with the victim, not the grandmother.
Oh.
Mhm.
Back and forth. Grown, stand with her.
After you were arrested for the assault on her. So after you were arrested for the assault on her, were you still going back and forth after that?
No,
Okay. I'm just checking what those original bonds was. What's the address? Her address.
on 105 Trinity Groves.
Is that the address you have?
7110 Highway 105. 7110.
That's an apartment complex.
That's
Yeah.
where the complaining witness in the 7110.
Highway 105, apartment 725. Right.
That Beaumont.
Yes,
What's her name again?
Jasmine Briscoe.
Jasmine?
Jasmine.
Jaslyn. How do we spell that?
JAZZLY.
Briscoe?
Yes, ma'am.
Do y'all have any children together? What?
One
Who takes care of that child? Is it with her or somebody else?
with her, both of us security.
What's your grandmother's address?
On 190 Toledo Street.
Okay, what I'm going to do in cause number 23 DCCR 2323, grant the motion to set a bond, and at this time. Well, let me look back at something. So were there any issues? Any positive drug screens?
yes, when he got arrested in office, he tested positive for THC.
Right, I'm going to deny both of the motions at this time, to set bonds. I don't think it is, proper on probation for 2 felonies. We've got a new allegation of a serious, offense. Got positive drug screens, failing to follow through with the therapy. I think they're probably, if there's going to be a continuation of probation, needs to be something a little more intensive, if we even consider that. All right, you can go back with the bailiff. Mr. Roadhouse will be out there to visit with you, tell you what your options are. Sir, are you Desmond Bennett? And this is 25 DCCR 0718. Mr. Bennett is charged with deadly conduct, discharging a firearm. And what is the announcement?
Oh, the announcement, it's my understanding that the victim did not want to pursue the case, but the state is still gonna move forward with
Okay.
it. So with that being the case, offer was 20 years. I know from talking to him that he's not gonna take 20 years in prison.
Okay, did you do a plea bargain rejection?
No, I did
If
not.
you'll get that taken care of, I'll recall it as soon as you're ready.
And that's correct, Judge. We are in receipt of a non-prosecution affidavit from the complainant, but that's not going to affect our prosecution in this case.
Okay, all right, I'll hold it while y'all do that. Get the rejection done, please. Your indictment with you in clause number 25 DCCR 0718. You're charged with the 3rd-degree felony offense of deadly conduct, discharging a firearm, and that's from March 4th of 2025. Your indictment also alleges that you were previously convicted on July 17th of 2015, 2 cases of deadly conduct, which are 3rd-degree felonies. After those were final, you were convicted of manslaughter, a 2nd-degree felony, November 27th of 2019. What that means is that if you go to trial and you're found guilty in this case, and if those prior convictions are true, you would be considered a habitual offender, which means your minimum punishment would be 25 years up to 99 years or life in prison. Do you understand? And I have the plea bargain rejection that you've signed this morning with Mr. Adams that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, to go forward probably on just one of those priors, to make it a 2nd-degree felony with a 20-year sentence in prison. You have every right to reject that and have your cases set for trial. Just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial? Mr. Nichols, is there any reason to believe that that offer would change?
No, Your Honor, if he's found guilty at trial, we'll be proceeding on the habitual enhancements and we'll ask the court to stack his sentences, Your Honor.
I do want to make sure you understand that after today, I will not accept this plea agreement. If something changes, there's some information that comes up that either your attorney or the district attorney doesn't know today, then we'll talk about it. But other than that, once your case is on the trial docket, it's expected to go to trial. Or if you change your mind and you want to plea, it would be to something different than this. Do you understand? All right, we'll get your case set for trial. Mr. Adams will begin preparation.
Thank you.
Thank you, Your Honor.
Thank you.
And at 1 o'clock.
Yes, see you at 1 o'clock.
What we just witnessed was more than a routine courtroom proceeding. It was a clear demonstration of how quickly a defendant's past decisions can shape the consequences standing directly in front of them. In the first case, the defendant entered guilty pleas to 2 counts of assault on a peace officer and a controlled substance offense. The judge carefully established that the pleas were voluntary, that the defendant understood the consequences, and that she was competent to stand trial. The sentences, 5 years on each assault and 20 months on the drug charge, were ordered to run concurrently, meaning they would be served at the same time. But the next hearing showed a very different legal battle. Jalen Hendricks was asking for bond while facing probation revocation proceedings. His attorney pointed to his limited resources, family support, and willingness to comply. But the prosecution and the judge focused on the bigger picture: previous felony probation, a new serious allegation, a positive drug screen, and failures to complete required therapy. The judge ultimately denied both bond requests, explaining that the circumstances raised serious concerns about continued probation. And then came perhaps the most consequential moment of the hearing. Desmond Bennett rejected a 20-year plea offer,